Welcome to today's webinar, brought to you by the Current Consulting Group and sponsored by DrugPak. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled, What Every Employer Should Know About Marijuana, but Too Many Don't. Today's webinar qualifies for one continuing education credit from SHRM and HRCI for those who attend in its entirety. You will receive information following today's webinar on how to apply for that credit. Once again, today's sponsor is DrugPak. DrugPak has been a trusted name in the industry for over 35 years. When it first launched, it was the only comprehensive drug testing management software available. As the drug testing industry has evolved, so has DrugPak. At the forefront of innovation, DrugPak processes data faster and more efficiently. By integrating directly with laboratories and MROs, it helps transform the way business is done in the drug testing industry, making it easier for providers to deliver results to their clients. Today, DrugPak is web-based, mobile-enabled, customizable, and fully scalable to meet the needs of any drug testing program. The DrugPak team is passionate about creating software solutions that support the industry's diverse and evolving needs. Please visit drugpak.com to book a free guided demo tailored to your drug testing program, or email your questions to sales@drugpak.com. And now it's my pleasure to turn it over to our presenter, Bill Current from the Current Consulting Group.
Thank you very much, Greta, and welcome everyone to today's webinar. I want to also tip my hat to DrugPak for sponsoring today's webinar. Every year, the Current Consulting Group does a survey of the drug testing industry. We're right in the middle of that survey right now. We'll be presenting the results in April at the NDASA conference in Anaheim, California. And as part of that survey, we do what we call a brand name recognition survey. It's sort of a survey within the survey. And each year, DrugPak scores among the very top brands in the drug testing industry. Often number one in the category of software and cloud program management. And they've been around for a long time. A lot of people know who they are, but they do so many things. And so I'd recommend that you check them out at their website and learn more about what DrugPak can do for you. We're going to talk about, let me just advance a couple of slides. There's a slide in the slide deck on the services that we provide. I refer you to them. In particular, Current Compliance, that's our state law database. A lot of the information I'm going to share today about marijuana laws and marijuana legislation is part of a subscription to Current Consulting or Current Compliance. And so if you're interested in that, if you want to stay up to date on a month-to-month basis with developing legislation at the state level and federal regulations, let us know. Current Compliance, I think, can help fill that need for you. We're going to talk about the legal status of testing for marijuana within the context of legislation at the state level and fairly recent new laws at the state level, with the understanding, of course, that marijuana is still illegal at the federal level. But I'm sure, as many of you know, back in December, President Trump proposed moving, or actually signed an executive order that would reclassify marijuana from Schedule 1 to Schedule 3. And that's a big move because it takes it out of the category of other dangerous drugs like heroin and cocaine and puts it into a category with Tylenol with codeine. And so it doesn't seem to actually belong in Schedule 3. But it's important to note that by moving it to Schedule 3, it does not legalize marijuana at the federal level. So the state laws that we're going to talk about today and that you're probably grappling with right now are in contrast to the federal law, which still considers marijuana to be illegal. And so we're going to talk about those things, marijuana impairment, and as we have time at the end, I'll share some information about calculating your return on investment from drug testing within the context, of course, of the marijuana situation. Now, I have a new book coming out called What Every Employer Should Know About Marijuana. That will be launched at and debuted at the NDASA conference, but if you're interested in that, it's going to be an electronic book, but if you're interested in it, let us know. Send us an email and we'll make sure that you get a link to that book so that you can check it out. So in 2026, we're seeing a ton of legislation, and a lot of it has to do with marijuana, and a lot of that legislation would have a direct impact on the workplace. And it's sort of a redefining. There's hundreds and hundreds of bills out there. Most of them won't get passed. Most of them won't get enacted. But it's sort of redefining the balance, if you will, between employee rights, marijuana using employee rights, and workplace safety. And so while it expands, a lot of this legislation expands protection for medical marijuana users in particular, it also looks at employer immunity provisions. In other words, protections for employers who prohibit employees from using marijuana at work or being under the influence of marijuana at work. And that's sort of the balance, right? Because a lot of the marijuana laws at the state level give certain protections to marijuana using employees, especially if they're registered medical marijuana users, but at the same time acknowledging that employers have the right to secure the safety of their workplace and prevent employees from being at work while under the influence and possibly impaired by marijuana at the same time. So when it comes to medical marijuana laws, there are approximately 22 states and the District of Columbia, as well as a number of city ordinances that would require certain accommodations for medical marijuana users. We're talking about people who are registered with the state as, medically certified to use marijuana. So some examples are Arizona, Arkansas, Pennsylvania, Virginia, and this particular language is indicative of what you see when it comes to requiring accommodations for medical marijuana users. That second bullet, the sub-bullet, no employer may discharge, threaten, refuse to hire, or otherwise discriminate or retaliate against an employee solely on the basis of such employee status as an individual who is certified to use medical marijuana. That's the key. They're certified, they're registered with the state to use marijuana for medicinal purposes. Positive marijuana tests for non-certified workers those individuals would not qualify for the same protections. Now, when it comes to recreational marijuana laws, there are 10 states plus the District of Columbia that have these types of accommodation, or this type of accommodation language in their recreational marijuana laws. There are 40 states that have legalized marijuana to one extent or the other, but they don't all have this accommodation language in them. Here are some examples: Connecticut, Illinois, Montana, New Jersey. Quote, it shall be unlawful for employers to refuse to hire or to discharge any individual because the individual uses lawful products off the premises of the employer during non-working and non-on-call hours. That's the key, right? These lawful use laws have been on the books for many, many years in many states, where employers cannot discriminate against smokers, for example, people who smoke cigarettes. Well, these are now being applied, and sometimes language is being put into recreational marijuana laws that essentially does the same thing. It protects the marijuana user who uses the lawful product, because it's been legalized in their state, from some kind of discrimination against them for using marijuana by their employer. Look at that sub-bullet. Recreational marijuana is specifically included in the definition of lawful products in some of these states. Now, the last bullet, typically the employer should not take employment action on any positive marijuana test without additional factors such as evidence of impairment, and I've got a bunch of examples of that coming up. There are some other marijuana laws out there that are sort of atypical. California and Washington, for example. These two states have passed laws that would prohibit employers from testing workers, and in California also, or excuse me, I should say applicants in both California and Washington, and employees also in California. Washington only includes pre-employment testing, that would prohibit employers from testing for marijuana with a test that is only capable of revealing the presence of the metabolite of cannabis, not the parent drug itself. So for example, if you're using a urine test, urine typically identifies the cannabis metabolite, whereas oral fluid, you're identifying the parent drug itself. So you wouldn't be able to test for marijuana in California and Washington, and again in Washington it's just pre-employment screening, with urine if you want to test for marijuana and be able to take some type of action, adverse employment action, refusing to hire somebody based on a urine test result for marijuana. You could use urine in Washington for employee testing, but in California, neither employee or applicant testing can be done with urine if you're testing for marijuana. You can, however, use oral fluid testing because it's not detecting the metabolite of cannabis, it's detecting the parent drug itself. So, and because of that, you have a whole different set of parameters in California and Washington when it comes to testing for marijuana. Now, in California, there is an exception for the construction industry. So you can test in the construction industry with urine and still test for marijuana. In the state of Washington, it's a long list of exceptions, occupations that are accepted from the law. So look that up, but it does include safety sensitive types of jobs where an impaired worker could cause death or injury to another person. New York is kind of unique in that the Department of Labor in the state of New York came out with guidance on marijuana testing that essentially prohibits employers from testing for marijuana. But if you read that guidance very carefully, there is reference to other state laws that would allow testing for marijuana in very limited circumstances, like a reasonable suspicion test where the individual is suspected of being under the influence of marijuana, and then you could test for marijuana. But look up that law very carefully, because generally speaking, most people consider testing for marijuana to be prohibited in New York. And in Nevada, refusing to hire somebody on a pre-employment test that's positive for marijuana would be prohibited, especially and particularly if they're a registered medical marijuana user. So it's important, in light of all of this and other examples I'm going to share, that all states allow employers to prohibit individuals from being impaired by marijuana while working, or possessing or using marijuana while on the job. Okay, and that should be the bare minimum that's in any workplace policy, prohibiting individuals from being impaired on the job by marijuana, or bringing marijuana into the workplace, or using marijuana while on the job. That could include during breaks, lunch breaks, etc. So keep that in mind as we go through some other examples. Here's Minnesota. So in 2025, Minnesota updated its marijuana law to put some new restrictions in there when it comes to the written notice requirements before an employer can take adverse employment action. And that, I should say, that's part of the Minnesota drug testing law. But it also prohibits employers from discriminating based solely on the medical cannabis enrollment of an individual. You know, they've enrolled in the medical cannabis program in Minnesota, or for taking action based on, or discriminating, let's use their language, on a cannabis positive test, unless the use or impairment occurred at work. So again, going back to that previous slide, prohibiting individuals from using marijuana at work or being impaired by marijuana at work is still, you still have the right to take some type of adverse employment action when it comes to marijuana in the state of Minnesota. Currently, right now, there are some interesting bills that are working their way through state legislatures. In Florida, there's two bills. Both bills would grant employers immunity from civil liability if they take action based on a marijuana test. Now, if though the cannabis use, the marijuana use or possession occurred in the workplace, the individual is impaired while performing job duties, and the individual tests positive under a compliant drug testing program here in the state of Florida, where I live and where Greta lives, and many of our employees at Current Consulting Group, there's Florida Statute 112.0455, which is known as the Florida Drug-Free Workplace Act. And that has specific guidelines on how an employer must conduct drug testing. And so as long as you follow that Drug-Free Workplace Act, then you could take action based on a positive drug test result for marijuana. But again, we're talking about use that occurs at work or being impaired while on the job performing job duties. The takeaway from this is, if you're in Florida, but think about it applying to many other states, You want to reinforce your employer protections in your policy and make it clear to your employees as they read your policy that these are the things that we as an employer can do and will do in the event that there is suspicion of an individual being impaired while on the job. In Georgia, now Florida and Georgia are kind of connected at the hip in a way because they were the first two states that passed workers' comp premium discount laws. This was many, many years ago. And so they kind of, in a way, kind of moved forward in lockstep, not exactly, but to some extent. But there's a bill in Florida that for recreational legalization that it contains no employer provisions. This is key because many states that initially legalized recreational marijuana use will completely ignore the workplace or any employer provisions. Sometimes this is done, I think, to get the bill passed. And then later, as we see in so many states, they come back with new language and amendments to that bill, that new law, that would, excuse me, then add provisions for the workplace. So right now, nothing about the workplace, but you want to keep an eye on that. The key takeaway in Georgia is that recreational legalization proposals without workplace language can create ambiguity, even though as an employer, you're still going to be required to comply with that law. But when it doesn't give you any guidance as an employer, it can be a little bit dangerous. Indiana and Illinois, two states with progressing legislation. In Indiana, legalizes medical and recreational cannabis, but it explicitly protects employer zero tolerance policies and clarifies that prohibiting work while under the influence is not unlawful discrimination. Very important there. As I said, in Georgia, we don't have that language in the bill that's progressing, but in Indiana, they were cued in enough to include that. Keep an eye on that bill if you're an employer with business operations in Indiana. In Illinois, it's very interesting, right? Because a lot of states have legalized other drugs. You may remember some years ago, Oregon legalized everything, and it went so poorly that they had to undo the law. Well, in Illinois, SB 2184 would legalize psilocybin, but it does not prohibit an employer's ability to restrict the use of controlled substances by its employees or the legal standard for negligence. So keep that in mind. Keep an eye on that bill in Illinois if you're an Illinois employer. A lot of these state marijuana laws do create confusion for employers, and I think that's partly the result of the fact that there are just so many of these bills constantly every year, literally hundreds of them, that would either legalize marijuana or in a state where medical marijuana is already legal, legalize the recreational use of marijuana, or in cases where there's already a legal marijuana law on books that would kind of further erode the rights and abilities of employers to take action in the event that somebody brings marijuana into the workplace. The objective is always to expand the protections of employees who use marijuana. That's the objective of the marijuana legalization movement. But employers do have the right in every state to prohibit employees from bringing marijuana into the workplace, being impaired by marijuana while on the job, and using marijuana while working. Very interesting, though, that people always ask, if marijuana is legal in our state, does that mean we can't test for marijuana? And I used example of New York earlier. Testing for marijuana is legal in every state. You can do it in every state. There may be restrictions on what you can do with a marijuana positive, or there may be restrictions on how you test for marijuana, like in California and Washington. But even in New York, there are some very narrow paths to testing for marijuana. You just need to look at the laws that apply to you. And I get asked this question all the time. We're in multiple states. Which law should we base our policy on? Well, unfortunately, you have to base it on all of them. So you may have amendments to your policy that cover specific restrictions that exist in certain states. And this is very common when it comes to marijuana. But as I said, you have the right in all 50 states, in every territory, to prohibit employees from bringing marijuana into the workplace, using marijuana while on the job, or importantly, being impaired or under the influence of marijuana while working. So let's pause now. Let me turn it back over to Greta for our first poll question.
Great, thank you, Bill. I will launch the first poll question. Okay, so how is your organization currently handling marijuana testing? Please choose one of these answers. We still test for marijuana and take action on positives. We test, but don't always take action. We have removed marijuana from our panel. We are considering removing marijuana from our panel. Not sure, still evaluating. I'll give everyone a few seconds to participate, and thank you for participating. Okay, so let's go ahead and share those results. 69% said we still test for marijuana and take action on positives. 17% says we test but do not always take action. 6% said we have removed marijuana from our panel. 2% said we are considering removing marijuana from our panel. And 6% said not sure, still evaluating. Back to you, Bill.
Okay, thank you, Greta. That's interesting. 59% of you said that you still test for marijuana, you're still taking action. That's probably lower than it's been in the past several years. We've seen that number coming down a little bit. Also thought it was interesting that 6% of you have already removed marijuana from your drug test panel. You're gonna hear some more information in this presentation today that could expose you to some legal liability by doing that, but that's a decision that you make, and you've got to be prepared for that. And 2% of you are considering removing marijuana from your panel. So I hope today's presentation helps you a little bit with that. Let's shift gears a little bit now and talk about marijuana-related impairment in the workplace. So there are a number of surveys that come out on this issue, and we track all of these things here at Current Consulting Group. Let me share some of the results. These are not surveys that we did in every case, although I will refer to some of the Current Consulting Group surveys. So there was a survey of 500 employees who admitted to being marijuana users, and 31% said that they use marijuana during their commute to the workplace. So that's significant. They've used marijuana, say, within an hour of starting work. I'll come back to that in a second. 77% said they use marijuana at home before leaving for work. So again, within, say, an hour, if the average commute to work is an hour, and if you live down here in South Florida, it's longer than that if you're going into Miami, probably. But 77% said they use marijuana before they leave for work. There was another survey of 1,000 admitted illicit drug users, so not necessarily exclusively marijuana users, although that's by far the most used drug. 28.2% said they get high on the way to work. So pretty much in line with that 31% above. Now, in our 2024 drug testing industry survey, we asked drug testing providers, does dropping marijuana have an effect on, employees' attitudes towards marijuana? 59% said they believe the decision by the employer to discontinue testing for marijuana actually encourages employees to consume marijuana before work. Now, another survey. This was one that found 1 in 5 said that they use marijuana recreationally in the workplace during work hours. And in that survey of 500 marijuana users, 48% admitted to using pot at work. So a whole bunch of people are smoking pot on the way to work, and a whole bunch of them, 48%, my goodness, that's a lot, admit to using marijuana while at work. Now, these are admitted marijuana users. There was a different survey of 1,000 admitted illicit drug users that I referred to on the other survey, where 22% admit to getting high while on their lunch break, 11% getting high in the afternoon while at work, so after their lunch break, 10% getting high in the morning before their lunch break, and then when work is done, 5% said they continue getting high on the way home. This is all very important because employees are under the influence of marijuana at work. There's just no way around it, right? Because the effects, the impairing effects of marijuana linger beyond just those first few minutes after somebody's used marijuana. Let me go to this next slide. This was a 2021 analysis of 80 different studies from around the world on the subject of the window of impairment. How long does impairment from marijuana last? Now, we know that in some cases, marijuana impairment starts within minutes after somebody has consumed the drug. But look at that second bullet. Impairment may last up to 10 hours if high doses of THC are consumed orally. A more typical duration of impairment, however, is 4 hours when lower doses of THC are consumed via smoking or vaporization, and simpler tasks. And let me just point out that S in vaporization is a direct quote. That's how they spelled it, and that's how they spell it in other countries. So instead of the Z, it's an S. And simpler tasks are undertaken, those using cognitive skills such as reaction time, sustained attention, and working memory. This impairment may extend up to 6 or 7 hours if higher doses of THC are inhaled and complex tasks such as driving are assessed. So when somebody's smoking marijuana or using it in some other form just before leaving for work or during that average 1 hour commute to work, they're high on marijuana when they get to work. They're high on marijuana for some period of hours during the workday. And if they're using marijuana during a break or during their lunch break or in the afternoon, some period of time in which they're on duty, when you're paying them, they're under the influence of marijuana and probably impaired to a certain extent. Of course, that impairment will manifest itself more acutely depending on what they're doing, like, as it says there, complex tasks such as driving. If you're employing a driver and they're smoking marijuana on their way to a sales call or some other duty that they're hired to do, then they're probably high while they're doing that. And you'll find some examples of that in the book that I told you about, What Every Employer Should Know About Marijuana, because I found lots of examples of that. Now, Quest Diagnostics, which is the laboratory that is always ranked #1 when it comes to our brand name recognition survey for lab-based urine drug testing, reported in 2023, or reported that in 2023, so this was from their 2024 drug testing index report, that post-accident positive drug tests for marijuana reached a 25-year high. That sub-bullet, first sub-bullet. In 2022, post-accident drug marijuana positivity for urine tests in the general U.S. workforce was 7.3%, an increase of 9% compared to the 6.7% in 2021. The new peak follows a steady increase in post-accident marijuana positivity every year between 2012 and 2022. Now, this past year, in the 2025 report that reflected 2024, the positivity rate had gone down just slightly, but it was still right in that same neighborhood of, the mid 7-point percentage area. So you want to take a close look at your drug testing policy when it comes to testing for marijuana, because if you're not conducting pre-employment drug tests, you're hiring more drug users and you're hiring more people that are more likely to cause an accident. I've got some stats coming up on that in a minute, but let's stay on the subject of impairment for a second. So these are just two examples. I won't go into a lot of detail, but they talk about impairment in the bills. Now, a drug test does not prove that somebody is impaired. They test positive. That's not scientific or legal proof that somebody's impaired. It does prove that they had drugs in their system at the time of the test, and that alone may be against your company policy, but it doesn't prove impairment. So a lot of these laws, when they use the impairment or they require proof of impairment, you can't use the drug test result as the proof. There has to be something else that goes along with it. Now, there's a lot of impairment technology or detection technology out there today. Not stuff that we saw very commonly even 10 years ago, but now there's a lot out there, some really great products and devices and companies out there that provide this impairment detection technology. Some of it's computer-based, some of it's on a tablet, some of it looks like like a Pac-Man game or something like that. A lot of it's drug recognition expert-based, DRE-based. Some of it's cause agnostic. In other words, it's not identifying impairment from drugs specifically, just that the individual's impaired. And of course, that's the main thing, right? If you have somebody performing a safety-sensitive job, you don't necessarily want them to be impaired while doing that job, regardless of the reason for the impairment. So with oral fluid testing, because I get asked this question all the time, oral fluid testing also does not prove that somebody's impaired. A positive oral fluid test doesn't prove that somebody's impaired. But the difference between oral fluid testing and urine testing are pretty significant. The biggest difference is the fact that with oral fluid testing, because you're detecting the parent drug, you're able to detect drug use within minutes after somebody's used the drug. If somebody comes back from a lunch break and they smell of marijuana and it triggers a reasonable suspicion test and you test them with oral fluid, say you're using a rapid oral fluid test, then you're probably going to get a positive, right? Because that parent drug becomes detectable in an oral fluid sample within, say, 10 to 15 minutes after usage. Whereas with urine, it takes about 6 to 7 hours after usage for the metabolite of cannabis to become detectable in a urine sample. So that's pretty significant. Plus, you've got a shorter, tighter window of detection with oral fluid of about up to 24 hours, less in many cases. So you're really sort of identifying the drug use pretty close to when they use the drug. And again, I'm not saying that it proves impairment, but if you're suspecting impairment and you get a positive test with oral fluid, there's a shorter correlation or a higher correlation to the drug use and the suspicion of impairment that triggered the drug test. I might also point out that another advantage is it's virtually impossible to cheat on an oral fluid test, whereas with urine testing, there's a high probability of that. Now, I'm a fan of urine testing as well, and it's still the #1 drug testing method. Lab-based urine testing is still #1. But in certain situations, reasonable suspicion post-accident, there may be call for a different type of technology that can detect drug use, very quickly after somebody uses the drug, and that would be where oral fluid testing comes into place. So with that, let's turn it back over to Greta for another poll question.
Thank you, Bill. And for our second poll question, what is your biggest challenge when it comes to marijuana in the workplace? Proving impairment, keeping up with state laws, deciding whether to test for marijuana, managing safety-sensitive positions, or employee expectations, legalization concerns? And I will give everyone a few seconds. Thank you so much for participating. Okay, great. And now I'll go ahead and share those results. 26% of you said proving impairment. 26% of you also said keeping up with state laws. 8% said deciding whether to test for marijuana. 22% said managing safety-sensitive positions, and 18% said employee expectations, legalizations concerns. And back to you, Bill.
Thank you, Greta. Thank you, everybody, for participating in these poll questions. I thought it was interesting. Some of the biggest challenges you're facing have to do with, proving impairment or keeping up with laws that, in many cases, discuss impairment or require some evidence or proof of impairment before taking adverse employment action. And so it's got to be something beyond the drug test. And I've got some suggestions coming up in a minute. In addition to the drug test and in addition to impairment detection technology, there are other things that you can do, and we'll talk about those in a minute. So let's turn our attention now to calculating the return on investment of marijuana testing. Now, the numbers I'm going to share, and let me also say, feel free to submit any questions you have. I know we've got a bunch of questions already, but if you have any questions at all about drug testing or about the marijuana issue, anything at all, I'm happy to address those. And if there's something that we can't answer today, we will respond via email with an answer to your question. So ask any question that you'd like. We're happy to respond to those for you. So as I present some numbers, I'm going to just use some numbers that I chose to do the calculations. It may not be what you pay for a drug test. It may not be the percentages of employees in your workforce that you suspect are drug users, but I just came up with some numbers on my own for the purpose of the calculation. Okay, but I think they're pretty close. Even if the numbers are different that you would use, the end result is going to be very similar, right? Okay, so I'm going to compare urine and oral fluid testing, keeping in mind that marijuana is the #1 illicit drug being used by individuals in the United States. So this doesn't include alcohol, for example. But when you talk about drug abuse, most of it has to do with marijuana. Now we are seeing a surge in fentanyl abuse and how it's affecting the workplace. I know Quest Diagnostics came out with a great article on that recently that I found interesting. DrugPack has a bunch of information about that as well. But we're mostly talking about marijuana when it comes to drug testing and the positivity results from drug testing. So for urine testing, we're going to use again, these are my numbers, okay? So don't dispute the numbers, but do ask me questions about the calculations if you'd like. The price an end user, the employer, would pay for the collection, we're going to put in at $15, okay? For an oral fluid test, it could be $15 also, but oral fluid is so much easier to collect that you could do that on your own. You could, in other words, train employees to administer the test, and they could serve the function as a collector, even though they're really administering the test in the workplace, especially if it's a rapid result oral fluid test. Okay. Second category, the price that the end user would pay for the lab analysis. Now, this is typically a bundled price that includes, could be a bundled price that includes the collection, confirmation, MRO, but I'm just looking at it as a separate line item. I put it in at 18. For oral fluid testing, it's typically a little bit higher, so I put it in at 25. Those numbers are, they vary. The confirmation price I built in because usually that's built into your lab analysis price. So that $18 for a urine lab test or the 25 for an oral fluid test, I'm including the confirmation test if the initial screen is non-negative, but it could be a separate line item. Okay, for my calculation, I just put it in this way. And then I put the MRO verification service at $5 each. Could be much higher than that, of course. It could also be, sort of amortized into all the drug tests that you're projecting to do for a year, and it could be $3 or $4 or $10, but I put in $5. And so the price of the lab-based urine test is $38, and the price for the lab-based oral fluid test is $38, and for lab-based oral fluid, it's $30. So keep that in mind, right? The thing that you have to keep an eye on when it comes to drug testing is the soft dollar costs. So, we're talking about the hard dollars here. We know that the analysis, the collection, the confirmation, the MRO, these are the prices, right? But when it comes to the soft dollars, you can save money when it comes to oral fluid testing if you're doing the tests yourself in the workplace and you're not using professional collectors. And these calculations on this page only apply in that situation. So if you're still going to use a professional technician to administer an oral fluid test, then the number is going to be about the same, $67.50 on both columns there. But if you're going to do it yourself, you're going to train employees to do it, you might calculate some time for the worker to participate in the test or to administer the test. But generally speaking, I just used certain hourly rates and sort of took a percentage of that, and it came out to $67.50 for a urine test and $11.25 for the oral fluid test if you're not using a professional to administer the test. And so if you combine the hard dollars and the soft dollars together, you can see that you're paying a lot less for an oral fluid test if, again, you're willing to do those collections yourself or the administering the test. There is some additional cost to that, but it wouldn't be as much as the urine test with the $60 and $67.50. Now, you decide for yourself if this is something worth doing for you, right? But when we talk about marijuana testing, I think two major trends that we're starting to see, and we've been watching these for the last 5 years in particular, two trends that we're starting to see is a movement toward oral fluid testing. I think that is the result of two major developments: the widespread legalization of marijuana and the inclusion in many of these marijuana laws of quote unquote impairment type of language. And so oral fluid more closely correlates to when the drug was used. And so you might be able to kind of connect it to the time when the person used the drug and whether or not they're impaired in the workplace. Even though, again, I will repeat, the drug test, whether urine or oral fluid, does not provide legal or scientific proof that somebody's impaired, okay? But very important to keep that in mind. The other trend is that the U.S. Department of Transportation did finalize regulations for lab-based oral fluid testing. They're still not available for employers to use. We're still waiting for laboratories to be certified to conduct oral fluid tests as part of a DOT program. But the very fact that DOT did this, I think gave oral fluid testing a big giant boost toward its credibility. I think the credibility was already there, but this was a major move. So those two things, legalization of marijuana and DOT approving lab-based oral fluid testing, has moved a lot of employers toward oral fluid testing. And then the second thing that we're seeing a trend toward is impairment detection technology. So I'm going to talk about that in a second, but when it comes to measuring your return on investment for drug testing, you have to keep some things in mind, right? how much does the average substance abusing employee cost a typical employer? Well, there was a study from the University of Chicago that came out with a figure. It was just over $8,800 that the typical substance abusing employee, which are mostly marijuana users, are costing their employer. That's from turnover, because they're more typically going to change jobs in a year 2 to 3 times. Lost productivity because they're absent from work or tardy to work more often than non-drug using employees, and accidents and medical expenses, as well as workers' compensation claims. So there's lots of different types of accidents. And I put a bunch of different numbers on here, like the total amount, $176.5 billion, et cetera, et cetera. But what I want you to focus on is that last sub-bullet in the second category there. The average cost per medically consulted injury is $43,000. That's typically going to be part of a workers' comp claim, but not necessarily. But if it's a medically consulted injury, the average cost is about $43,000. According to figures from the federal government, marijuana using employee is 3.6 times more likely to cause a workplace accident, and that would cost the employer more than the $8,800, right? That's the average of all employees. But if there's an accident involved that results in some type of a medically consulted injury, or as I'm going to show you on the next page, a vehicular accident, then the cost could be much more than the average of $8,817. Could be in the tens of thousands of dollars. Now, the average workers' comp claim last year, or excuse me, between 2017 and 2018 was $44,179, okay? And for a motor vehicle crash, the average cost was $90,914 in workers' comp, okay? So that 8,817 is an average over many, substance abusing employees. But if a workers' compensation claim is filed, the average cost is $44,000. If it involved a motor vehicle crash, it's $90,000. And those are just the averages, right? That doesn't include, heaven forbid, a fatality that could be well over $1 million. So if you take that 3.6 times more likely to be involved in an accident, and you consider that drug users are 5 times more likely to file a workers' comp claim, medical consulted injury is $43,000, a workers' comp claim is $44,000, and you compare it to the average cost of a pre-employment drug test of, let's say, $40, right? Then you can see that it's a great investment. Drug testing is a great investment, because if you avoid hiring a drug user, you're saving on average over $8,800, right? But you could be saving a lot more, especially if you're in a safety sensitive industry where accidents are more common, where workers' compensation claims are more common, and possibly, with individuals operating a motor vehicle, you could be looking at, even higher costs. So one last thing I want to point out is that many states have workers' comp regulations that allow you as the employer to move to deny a workers' comp claim if you as the employer can show via a positive drug test result that the injured worker had marijuana or some other prohibited substance in their system at the time of the accident. Okay, so if the average cost of a workers' compensation claim is a little over $44,000, but for the cost of a $40 post-accident drug test, you can show that the individual was positive and had drugs in their system at the time of the accident, you may be able to move to deny that claim in your state. Now, again, a lot of these state laws, these workers' comp regulations, use the word impairment. Don't be misled by that. The drug test doesn't prove impairment, but for the purpose of the workers' comp claim challenge, if you've got a positive drug test result in many of these states, it will prove that the individual had drugs in their system, in most cases marijuana, or possibly alcohol as well. And many of these laws refer to both alcohol and illicit drugs, but it will prove they had it in their system, and you can possibly, very likely, successfully challenge the workers' comp claim. That's going to save you a lot of money, but you don't have that opportunity if you drop marijuana from your drug test panel, because that's the #1 drug that people test positive for. If you're not testing for marijuana and there's an accident, somebody files a workers' comp claim, even if you have a drug test result, if you weren't testing for marijuana, it's not going to show the #1 abused illicit drug in the United States. you got a pretty significant opportunity to legitimately save costs to your business if you're drug testing following accidents, and that drug test includes marijuana. So a lot of big brand companies that have dropped marijuana continue to test for marijuana in a post-accident scenario. The savings can be significant in safety-sensitive industries. Let me go back to this this point here on this slide. I said I would talk about different ways that you can show impairment and add it to a drug test result that doesn't legally show impairment. So if you're documenting these things, there could be a pattern of aberrant behavior or reckless behavior, or maybe workplace violence, an incident of violence or harm caused to another person, employee theft or accidents, an increase in accidents, even if they're not injury-related accidents, and a whole host of other things. But you have to document these things in addition to your drug test result if you want to take action based on a positive marijuana drug test result in a state that requires some proof of impairment. Again, acknowledging that the lawmakers use the word impairment incorrectly when it comes to drug testing, but we're clarifying that the drug test doesn't prove impairment, but a positive test for marijuana in combination with documented aberrant behavior or recklessness or violence, etc., may be all that you need as an employer to take adverse employment action, even in a state that's legalized marijuana. So if you're a drug testing provider on today's call, and we've got one more poll question coming up and then I'll take questions. But if you're a provider, you've got to know these marijuana laws because you've got clients that are affected by these laws. And you've got to be able to demonstrate the return on investment of testing for marijuana so that, and that includes these workers' comp laws that would allow an employer to challenge a workers' comp claim based on a positive drug test result, most of which will be for marijuana. You got to be able to demonstrate that ROI and possibly offer alternative testing methods. Now, 20 years ago, we've been doing our drug testing industry survey for this is our 28th year. So we've been doing it for a long time. Many years ago, certainly 20 years ago, very few drug testing providers were offering oral fluid testing. Today, most employers, at least let's say half, to be conservative, offer either rapid oral fluid testing or lab-based oral fluid testing or both. And so you want to be able to offer employers that alternative because as their interest in alternatives increases due to challenges they're facing from legal marijuana laws, etc., they're going to be looking for alternatives. They're going to be looking for options, and you want to be able to provide that for them. So before we get to Q&A, Greta, let's do one more poll question.
Thank you, Bill. And for our last poll question, let's go ahead and launch that. Do you believe marijuana testing provides a positive return on investment for employers? Please go ahead and select one of the following. Yes, absolutely. Yes, but only in certain roles. For example, safety sensitive. Not sure. No. It depends on state laws. I'll give everyone a few seconds to participate, and we do thank you. Okay, and let's go ahead and share those results. 67% of you said yes, absolutely. 26% of you said yes, but only in certain roles, like say safety sensitive roles. 2% said not sure, 0% said no, and 4% said it depends on state laws. Back to you, Bill.
Okay, Greta, I was just jotting down those results. Thank you again, everyone on today's webinar for participating in these surveys. I think it's interesting as we're talking to get feedback from you as well, and that helps us in terms of future topics for webinars to know the things that you're talking about. 67% of you said that you do perceive a positive return on investment from testing for marijuana, and 26% said yes, but probably only in certain occupations like safety sensitive roles, etc. And definitely, I think that's true in safety sensitive occupations as well. But thank you for doing that. We will be coming out with the results of our 28th annual drug testing industry survey at the NDASA conference, which is towards the end of April. If you're interested in getting a copy of the executive summary, let us know. Everybody who participates in the survey gets a copy of the executive summary, and then a couple of weeks later we release it publicly to anybody who would like a copy of it, or would like to see. We do a newsletter on the results of the survey, and you can get that as well. So if you're interested, just let us know in the Q&A section. We'll be happy to put you on the list to receive that. Greta, let's go through some questions.
Okay, Bill, great. So for our first question, how can employers test for impairment? Is there a threshold like alcohol?
Well, unfortunately, there's not. Like, I hear what you're saying about alcohol, right? We've got a national impairment standard of 0.08% BAC. I know the state of Utah, I think, has a 0.05% that they've initiated in that state. And so we know what a positive test for marijuana is by cutoff levels, right? And so whether it's 5 nanograms for a confirmation or 50 nanograms for an initial screen, but we can't equate that to a declaration that somebody's impaired. Will we get to that point? Maybe, but we're not making much progress toward that, having a national standard for impairment when it comes to marijuana. What we can do, though, is look at the data that's out there that essentially estimates the window of impairment, like from that University of Sydney study that I shared, and make the logical connection that somebody who's acting as if they're impaired in the workplace, who smells of marijuana, who maybe is caught using marijuana in the workplace, etc., who then tests positive with an oral fluid test because it's going to show that very, very recent use of the drug, that individual's probably impaired by marijuana. But you don't necessarily have to take action based on the marijuana test result, because you've got other things in that scenario that I just shared that would justify taking adverse employment action. They used in the workplace, they were acting strange in the workplace, it's all documented. And in addition to all of that, we have a positive test for marijuana with oral fluid, which shows very recent use. So no, we don't have a national standard for marijuana impairment like we do for alcohol. I'm not sure we're going to get there anytime soon, but it seems logical that we would have something like that, especially given the fact that so many states have legalized marijuana. So not a real good answer for you there in terms of are we getting there anytime soon, but that's the reality.
Thanks, Bill. For our second question, how will reclassifying marijuana from Schedule 1 to Schedule 3 affect drug testing?
That's a great question because there's a lot of confusion on that right now. So back in December, President Trump signed an executive order that would move marijuana from Schedule 1 in the Controlled Substances Act to Schedule 3. So as I said earlier, it takes it out of the category with heroin and cocaine and puts it in the category with Tylenol with codeine. Doesn't seem logical, right? Now, the standard for Schedule 1 is a drug that's subject to abuse and that has no known medical benefits or uses identified by the federal government. I don't know if it's still there or not, but not too long ago, I mean, even back in December and January, after this executive order was signed, you could go on to the DEA website and find a statement on there that there is no known proven medical benefit to using marijuana. So the government seems to be at odds with itself. And so we've got this executive order that moves it from Schedule 1 to Schedule 3. The first thing you need to know is that does not legalize marijuana federally. Okay, that's number one. Two, it does not make it illegal for employers to test for marijuana. You're still going to be governed by the state marijuana laws that apply to you. And even if the federal government legalized marijuana, it wouldn't do away with all of these state marijuana laws because there's so much detail in those state marijuana laws in some cases, and it's unlikely the federal government would pass or legalize marijuana and at the same time put restrictions on what employers can do. Probably another related question, I'm going to just assume, right, that if you're a DOT covered employer, will the reclassifying or rescheduling of marijuana prohibit you from testing for marijuana? Well, we don't know the answer to that question right now. There was some language in the executive order that made it seem as if existing federal regulations would not be affected by the reclassification of marijuana from Schedule 1 to Schedule 3. My guess is that regardless of that, employers in safety-sensitive industries will continue to test for marijuana. In our annual drug testing survey of employers, we do 2 surveys a year, this one of employers, a huge percentage of them said that they drug test to promote safety in the workplace. And if that's their #1 motivation, and marijuana is the #1 drug of abuse and the #1 drug that people test positive for, and the #1 drug that is responsible for workplace accidents related to drug abuse, then they're not likely to discontinue testing for marijuana. And even if they're DOT covered, they can do more than what DOT requires. They can test in other ways besides, as long as they're complying with what's in the DOT regulations. So many employers may continue to test for marijuana, even if DOT, and I'm not predicting this, but even if DOT were somehow not able to or no longer authorized to require DOT covered employers to test for marijuana, which I don't think will be the case, but I think most employers will continue testing for marijuana regardless.
Thank you, Bill. I think we have one more question. If a drug test does not prove someone is impaired, what can employers do to show that someone was impaired?
Well, that's a good question, right? So one of the things I talked about in my presentation was impairment detection technology. And there's lots of different products out there, computer-based, tablet-based, some of it based on drug recognition expert, concepts, etc. That's one thing that you can do, especially in safety-sensitive industries, where in a legal marijuana states, where they require some additional evidence of impairment in addition to a positive drug test result. This impairment detection technology, I think, is going to grow in popularity, especially in marijuana-friendly states, as well as in safety-sensitive industries. But in addition to all of that, #1, conduct annual supervisor training on the signs and symptoms of substance abuse. Make sure that the people who have management responsibility in your company are trained in how to spot the signs and symptoms of substance abuse, which is most often going to be marijuana or alcohol. Those are the 2 big ones, right? But then also make sure that you have procedures in place for documenting that type of behavior, so that at any point, with or without a drug test result, and maybe with or without a drug detection technology test result, you could take adverse employment action to prevent somebody from being in your employ, conducting safety-sensitive responsibilities and duties, and being impaired on the job. So in addition to drug detection technology and drug testing, in particular with something like oral fluid that detects recent drug use, I would recommend annual supervisor training on the signs and symptoms of substance abuse, when a reasonable suspicion drug test is justified, and how an employer would go about triggering that test so that you're protecting the workplace. Pre-employment testing deters people who are drug users from maybe applying for a job with your company, but random drug testing is a great deterrent to drug use after you hire somebody, and post-accident and reasonable suspicion also are high drug test results for positivity. So the highest levels of positive drug test results come from reasonable suspicion, as you would suspect, and also for post-accident testing. But that also puts you in a position to protect yourself in the event that you need to take action, based on somebody being in the workplace impaired. So that's it, Greta.
That's great, Bill. Thank you. This was a great presentation. And before we close out today's session, we want to thank all of you for joining us. On behalf of the Current Consulting Group and DrugPak, we hope you found today's presentation informative and helpful. If you submitted a question, we will answer you offline, and we will also send you information in a follow-up email on how to access the recorded version of today's presentation. And in addition, we will also send you continuing education information for those of you that qualify to receive 1 credit for attending today's presentation in its entirety. Thank you for your attendance today, and this concludes today's webinar. Have a wonderful day.